Tell me you have nothing without telling me you have nothing. What number of motion for sanctions are we at? Is this like the 7th one? Of course, this is coming on the heels of the recording becoming public, because the Lively team took a really big hit when the recording was revealed to essentially be useless to their claims. So they've come and hit the docket with something as hard as they could find. So discovery's ended in this case, and basically whatever the parties have discovered from one another, that's the evidence, that's the entire universe of evidence of this case. Meaning when the parties file their motions for summary judgment and or go to trial, the complete universe of evidence that they would draw from exists, is closed, that's it. And this motion is saying there are some signal text messages that they never produced. So we're entitled to this remedy as a result. Spoliation is the intentional or negligent destruction or altercation of evidence by a party. And it's a pretty serious accusation to make against a party, to make against lawyers. It's a really, really serious accusation to say you've been destroying evidence, because everyone knows you're not allowed to do that. Here, Lively is saying that the November 2023 17-point list placed Wayfair on notice that they should have reason to believe that litigation was incoming. Well, there was one line in that letter that says our client is prepared to pursue her full legal rights and remedies. That is so commonly stated in letters from lawyers to one another that it cannot be reasonable to expect that every time you get something with that line in it means you are about to get sued. So they're saying because we said that in November of 2023, you had to suspend all of your normal practices with respect to your text messages, with respect to your emails, with respect to any documentation, because you should have known that that meant we were going to come and sue you. I'm sorry, but that is ridiculous. Lively alleges that after that list was sent and that January 4th meeting was had, that there were no issues on set. So from the Wayfair perspective, there were no more issues to have to be on notice that there might be a lawsuit. Everything was kosher according to Lively. So then why would they have to go and change their Signal chat message record keeping settings? Why would they have to go change their practice if they believed that everything was fine? It's like if someone comes to your house and builds something, a construction project, and you're not happy with it, so you're like, I reserve my rights to seek legal recourse if you don't fix the thing that you have to fix. So they come in and they fix it, and then they go off their merry way and, continue with their normal practice of not saving ephemeral text messages about it. And then a year and a half later, you come back and say, actually, I'm going to sue you. And you went and deleted those messages when I gave you a warning that I could sue you if you didn't fix that project. Are you freaking kidding me? The only true demand letter or reasonable notice to the Wayfair parties that litigation was incoming was on December 20th, when a letter was sent to the Wayfair parties saying that a CRD complaint was filed and that they were reserving their rights to litigate those claims. And in connection to that, asking the Wayfair parties to preserve all documents. That would be a letter that would preserve or put the other party on notice to preserve documents. To be clear, documents after December 20th, because you can't go and retrieve ephemeral messages before if they're gone. Lively is literally saying that she cannot prosecute her claims because she doesn't have access to whatever amount of supposed messages there were on Signal before December 20th. She's saying that her entire retaliation claim cannot be prosecuted because of these supposed text messages. So they're asking for the most extreme possible remedy as a result of this theory that these documents were maliciously deleted. They're asking at this stage, which frankly is just way too early to be asking for this, they're asking for a specific jury instruction that instructs the jury that the Wayfarer parties have intentionally deleted evidence that supports Lively's claims, and therefore they should make the inference that those documents would have supported her claim. Essentially, it would be an instruction to the jury that those facts that she alleges are deemed admitted as true. That's insane. Of course, they didn't stop there, and they're like, we should also get our attorney's fees for having to file this. We have to ask, why are they filing this right now? Well, there's motions for summary judgment coming, aren't there? November 12th, we will be getting motions for summary judgment from probably both sides that lays out all the evidence. Meaning Lively will lay out the evidence why she believes she wins, and Wayfarer will lay out the evidence of why they believe they should win on all of the claims. And knowing that that is coming, knowing that that is going to be damning, they're filing something with hopes, I guess, that the judge is going to rule on this before the motion for summary judgment. I doubt it. Asking for an adverse inference for the jury when you haven't even resolved the issues that are going to go to the jury is really rich, which makes me think that this was another attempt to deflect from the bad PR that the release of the recording did for them. Because the judge is going to want to narrow the claims that are left for the jury first before deciding issues of what kind of evidence is going to come in and out. That's what motions in limine are for, that are filed before a trial. And they jumped the gun because they needed to react to the public outcry from the Steve Sarowitz recording. I see it only as a desperate move. I think it's embarrassing. I think it says we don't have anything to bring our claims, and this is the only way that we can possibly save it at this point. And I would be shocked if the judge rules on this before the MJOP and the motion for summary judgment that are all coming that he wants to resolve before any of this kind of stuff.